Welcome to another amazing episode of the Plan Your Federal Retirement Podcast. I'm your co-host, Micah Shalansky, and we got a special episode today because we have guesting in with us another great advisor, Christian Sakamoto. Christian, thanks for joining us again, bud.
Hey, Micah, super glad to be here and excited to go through our topic today. We're chatting a little bit about it beforehand, but I don't know, I'm really passionate about this subject, so I'm looking forward to it.
Yeah, this is really good. This is something that almost cannot be talked about enough. Now, I know what our listeners are thinking. Taxes. Don't you worry. We will talk about taxes, but it's not just about taxes. But this is something that in our financial planning process that where we go through, this is a key thing you got to start off with for many important reasons. And I can share some stories as to why it is that. But it's also something that a lot of people think they have done because mentally they've thought about it and they've worked a little bit towards it, but they don't actually have it done or they don't have it correct in what they want. And it's one of the irreversible things, right? If something happens, there's not a lot we can do to fix it when it's done wrong. So it's worth a little bit of time and attention to put it together.
Yep, I agree.
Yeah, so I was going to say on that, so the biggest thing that we're talking about here, and the listeners have probably guessed it since you knew it wasn't taxes, it's estate planning, right? It's irreversible mistakes that happen when you pass away. Now, most of the time, Christian, because Christian is a financial advisor on our team as well, most of the time, Christian, when we're working with clients, we get to see this in advance and fix problems, right? Because clients are coming to us when they're still alive, which is really nice. But when we get either, and we're going to talk about this when things go wrong, a nice little segment on that. But when we talk about this with clients when a loved one has passed away and they're not in control and things are happening, or if a new client comes into us and someone has passed away, we can't really change what's already been done. We have to work within the laws that we have. And so it's really important to spend the time and energy and effort to make sure that this is set up correctly.
100% agree. While we're working with our clients, they're still alive, we have the opportunity to work on this together and plan ahead, as opposed to working on the other side when we're trying to put out fires and those sorts of things. So the irreversible decisions, key word there. Let's focus on that today. Some of the concerns that we'll have, some of the concerns that we'll face, and then talk about some of the other documents we need. And at the end, we'll talk about some of the things that can go wrong with this stuff.
I love it. So let's go through timelines. Let's talk about documents. Let's talk about things that'll go wrong and always end on action items, right? What are things our listeners can do this week to help improve them in that situation? So Christian, to kick it off, let's talk about timelines. One of the questions I get asked kind of frequently when people pass away is like, what is my timeline? What do I have to do? Most of the time, the answer is you don't generally have a rush timeline. Sometimes that's a different story, and we're going to go through that. But most of the time, there's not financial things you have to get done right away. You can have time to go through the grieving process and to go through the funeral process, etc. But there's a couple of exceptions to that rule. So let's go ahead and kind of run through those.
Yep. And so the first one is when it comes to the TSP, there's actually a 90-day rule with the TSP that we have to make a decision, right? And within those 90 days, we're either choosing to keep it as the IRA. If it's going to be from a spouse, it'll continue in that spouse's name, or we're going to have a choice to get it out of the TSP. So do you want to chat a little bit more about that 90-day rule?
Yeah. So the way it works, and we had a great episode with Kim Weaver from the, I always want to call it the TSP office, but it's not the TSP office. She is the Director of External Affairs at the Federal Retirement Thrift Investment Board. Great podcast with her talking about this in some places where it goes wrong. So you can check that episode out as well. But basically the 90-day rule from the TSP says, after they've been notified upon death, that's a key point. After they've been notified upon death, they then will move the money out of the TSP participant's name into a different beneficiary or inherited account, and then they're going to notify the beneficiaries. The beneficiaries have 90 days to tell the TSP what they're going to do with that money. If the beneficiary does not tell the TSP what they're going to do with that money in 90 days, could be several reasons as to why they don't, by the way. If they don't tell them what they're going to do in 90 days, the TSP does a forced liquidation, sends a check for the entire amount. There is no undo button. There is no rollover. As our listeners are really savvy, they know when you take money out of TSP, the first person in line is our favorite Aunt Iris, right? Aunt Iris is there, the IRS. And so this could be a bad option. So this is one of the things that we need to make sure, kind of our soonest timeline that's normally there is that 90-day marker with the TSP. And again, I don't think it's the TSP, boy, how do I say this? It's the TSP's rules that they have to follow, right? So it is the rule that's there. We got to know how it works. We got to know what our options are.
Yeah. So another timeline that we want to look at is that 9-month rule for beneficiaries. And you have 9 months for notifying whatever account it is coming from. In this case, TSP, or maybe it's an IRA or any other type of account. We got to have nine months in order to notify if it's going to be a trust there.
Yeah. So if we have a named beneficiary as a trust, right, on the account, which is how my accounts are. We'll talk about beneficiary naming in a second, but my wife and I are first. I have a trust as my contingent beneficiary. Christian, I know you're doing the same concept here because trusts are such a good planning tool. But what that means, if my wife and I pass away, you have to, within 9 months, the custodian knows that you've passed away, but within 9 months of the date of death, they got to get a copy of the trust documents to say what's supposed to happen with the money. Now, most custodians, the Schwab, Fidelity, TD, Vanguard, whomever, right? Most of them want those trust documents up front. Just because they get the documents up front, that does not alleviate the 9-month rule. Let's say you've had this account for 15 years and Schwab has lost the documents. Or I'm just picking on Schwab for fun, right? They're a great custodian, but let's say 15 years is a long time. They don't have your trust document anymore. Have you satisfied the 9-month rule? No, you have not. So you have to do that. If not, it really limits the taxation deferral benefits we could have by that 9 months. So really important, if there's a trust beneficiary, we reach out to the custodian. We make sure they have a copy of the trust. We make sure we know how this thing works. Really important. Christian, what about tax returns, right? This is another kind of question we get. Someone has died. Let's say it's a parent has passed away. Now the kid's executor, personal representative, whomever's taking over. When are tax returns due?
Well, it's going to be the same for them as it is for us. It's going to be that April 15th of the following year for their tax return. And of course, we have that 6-month extension, should we need it, to push it into October, but it's still that April 15th date.
Boy, don't say should we need it like that. I use the extension every year, right? It's a good planning tool.
Hey, fair enough. Fair enough.
Hopefully getting my taxes done for last year soon. All right, but on that note, so no, the extension is really powerful. There's also estate tax returns, which could have different deadlines. Most people don't need to file estate tax returns. It is a little bit of a misnomer. It really depends too, and we're going to talk in this, Christian, in the documents you need. It really depends on how things were set up. How were they owned? Who are your beneficiaries, etc. But there's normally always a need for an individual income tax return. Now, even if there's not a need, not a requirement by the IRS that you have to file one, I'm a huge fan of filing a final tax return. Why? We start the clock on statute of limitations, right? Now the IRS has 3 years for that statute of limitations to run out, assuming we didn't commit fraud, because then there is no statute of limitations. So pro tip, don't commit fraud for many reasons. But then that way we stop it, right? Because what could happen? Well, the IRS could 5 years later, if you don't file a tax return, say, hey, why didn't Sue get a tax return, and create all of this issue that you have to deal with. So I'm a big fan of anytime we can kind of limit things in that statute of limitations, let's punch the clock, let's get it done.
That's good advice. Absolutely.
Boy, another one that really comes up again, let's say a parent's passing away, is these RMDs, these required minimum distributions. I know it's been a hot topic this year we've been talking about because of Secure Act 2.0. A lot of laws have changed. But Christian, let's kind of run through a scenario real quick. Let's say you're inheriting an account, whether you're the personal representative that's to take care of this, or you're a beneficiary that's going to get money. And let's say the person was over their required beginning date, right, when they have to start taking RMDs. So let's say that's 73. They have RMDs that are coming out, but they pass away and haven't taken their RMD for this year. What has to happen?
Well, once RMDs start, they can't stop. So if the person who passed away...
But the person's dead. What do you mean they can't stop? The person's dead. The IRS says they got to keep going?
Well, whoever inherits that account, the rule says that the RMD has to continue. And so if that person that just passed away, if they had already taken it for the year, then the person who inherits it, they do not have to for the year. If they didn't, then the person who inherits needs to take that RMD. Rules are going to be a little different for spouses versus if we're going to be inheriting, from a parent or a sibling or that sort of thing. Just because with spouses, there's a little bit of a distinction between the account being an inherited account versus maybe we take that account and roll it, or rather transfer it to our own account. And there's some planning tips and tricks to think about when we do that.
You bet. Now, I know, Christian, when we're talking on the podcast, we're talking with clients, sometimes we'll do the same thing you said, roll. That means transfer, right? We want to go ahead and use those words together. Yep. And really what we'd ask our audience, if you could remove one word from your vocabulary, it would definitely be the word rollover, and only use the word transfer with things. Now, sometimes we're going to say them because we want to make sure we're talking about the same thing. And just understand, those can be two totally different things, right? You call up and ask for a rollover. You may get a rollover, which is not the same thing as a transfer, and transfer is normally what you're trying to go for. But you bring up a great point on those RMDs. Once they start, they don't stop. They got to keep coming out. So it's really, really important. So I think those are mainly the timeline things that kind of catch people, right? So we kind of have that kind of taken care of. Let's talk about the documents that you need. Now, Christian, we always say that there's 3 documents people have to have. This is, of course, our opinion, but you have to have some optional ones as well. But run us through those. What are those 3 documents we have to have?
Yeah, so the first 2 are applicable when we're still alive, and we're in a situation where we're incapacitated is when they would kick in. So those first 2 would be an advanced healthcare directive. Some states call this a living will, but for general purposes, it's going to be that advanced healthcare directive. And then the second document is a durable power of attorney. And again, both of these documents are for when we're still alive, and in situations where we want to have a document for financial decisions, but also healthcare related decisions when we're in a spot where we can't make those decisions ourselves. Now, the durable powers of attorney, that's a very powerful document. And if we're married and we're in a situation where we're really trust our spouse or whoever it is that we're going to add to these documents, we don't have to use the durable power of attorney when we're incapacitated. We can use them while we're, still in a good spot, but we can also add those rules to those documents where they only are applicable or kick in, or rather springing at incapacitation. So I think those are super important documents to have if we're ever in a situation where we can't make those types of decisions for ourselves. Again, on the healthcare side, what are those health-related decisions that we want to have made for us? Do we want to stay plugged in or not, right? Do we want to have the artificial nutrition or not, right? These are very important decisions that we don't want to put that burden on our loved ones to make for us. It's a lot better for us to make those decisions now instead of not having them have to think about them after the fact. And it's kind of the same thing on the power of attorney side. That's more for financial related situations. And it's very helpful if, let's say, there's happens to be like a utility bill that's only on one person's name or a spouse's name. Who's going to be able to go in there and pay that bill, and who's going to be able to have access to those types of accounts if we're in a hospital incapacitated, right?
On that, Christian, talk about a hot button item, right? Is I forget which utility it was, but it was only in my name, and I didn't really think about it because it was before my wife and I got married, and after we got married, I just kept it only in. I didn't even think about it. It's on auto pay, right? So it just keeps going. And then years later, Kelly goes to call the utility company, and her name is not on there, and she has no access to the account. Woo! Talk about a spicy topic for us to chat about that evening. I didn't know I was walking into. But sometimes, like in real life, that's going to happen, right? This wasn't. I was trying to keep her off of an account. It was just, it's on auto pay. Nobody thinks about I don't think about you changing utilities over, but this is where that power of attorney is super powerful, that she can step in and go ahead and do this and take care of it, which is great. The Advanced Healthcare Directive, I want to tell a little personal story with this one as well, is when my grandmother passed away on my mom's side, everybody knew what she wanted to have happen. She didn't want to stay plugged in. We thought everybody was on the same page, but she hadn't taken the time to fill out the Advanced Healthcare Directive with what her wishes were. She said, my mom's in charge. That's what she said. So Rosa, my mother, was the one that could make these decisions, etc. So, hospice, all those things. My mom made that tough decision, etc. They unplug her. She's passing away and whatnot. 3 a.m., my crazy Aunt Mary comes storming into the hospital. We call her crazy Aunt Mary for a reason. And she comes storming, and this isn't what my mother wanted. She didn't want any of this. What are you doing? You're killing her, blah, blah, blah. Throws this massive fit in the hospital. Drugs come back on. Life support comes back on. Like all of these things come back on. And we got to spend kind of a week going through this again and talk about the frustration and hassle that it caused inside of the family. When if my grandma would have taken the time and checked the box on what she wanted, it could have freed us from a lot of hassle and a lot of strife in this conflict. And again, this is just our personal experience. And so it's not enough to sign the form and to say somebody else should do this. It says, no, what are your wishes? Especially don't put that burden on your children. All right, that's my personal story on that one. So we got the advanced healthcare directive, super powerful. The durable power of attorney, also really, really important. Probably the most powerful document you're ever going to sign. What's the third one?
Well, the third is when we have passed away, right? And that's when the will, the last will and testament is going to be that third. You got to have documents. And depending on if we have, beneficiary designations or different titling, we might think that the will isn't necessary or isn't needed. And I couldn't disagree more with that. The will is what I would consider to be a backstop for a lot of the things that are in our lives, whether they're physical assets or financial assets that, again, we might have missed a beneficiary designation for, or we just want to split up a little bit different. The will is something that you absolutely need to have to direct where you want your stuff to go through the probate process. And so that would be something that we can chat a little bit more as to when would it make sense to instead, focus more on a trust-based plan or whatnot. But I think the will is definitely something that we got to have.
Amen. Those top three documents are something we have to have. Now, let's talk a little bit about order of operations, right?
Sure.
And we're talking about how this applies also to your TSP and your federal benefits. Is order of operations, number one, when you pass away, things first transfer by title. How was it owned? Individual, joint, etc. Now, joint tenants with rights of survivorship is a spouse term, so I owned it joint with my wife. We both own 100%. I die, Kelly gets 100% of that. If I own something joint with Christian, it's not the same. It's probably tenants in common. That means I die, Christian keeps his half, but he doesn't own 100%. I still own my 50%. So where does that 50% go? So titling is really important here. This is where trust can be super powerful because trusts come in right at the titling level. So ownership, number one, is how they transfer. Number two is beneficiary designation. Beneficiary designation is so important. We talk about it all the time. You have four beneficiary designations as a federal employee. You have your last paycheck, your TSP, your FIGLI, Federal Employee Group Life Insurance, and your pension. Those are four separate forms to go to four separate places. You need to make sure those get filled out because guess what? You cannot put your spouse on as an owner, as a title. You can't have joint with any of those things we just mentioned. Can your spouse be on joint with your TSP? No. Can your spouse be on joint with your IRA? No. Can your spouse be on joint with your FIGLI? No. These are all those individual things. You can't have joint, right? Not saying you don't want to, you just can't. That's why you gotta have these beneficiary designations in there. With beneficiary designations, Christian, you and I talk about this all the time. You should at least have two, a primary and a contingent. Primary, if something happens to me, everything goes to my wife. If something happens to both of us, where does it go? Now, if you're thinking to yourself and says, look, I got a primary beneficiary, but I don't have a contingent beneficiary, then you spell Micah, M-I, no, I'm just kidding, right? Okay. But you got to have a contingent beneficiary to make sure things are really clean. So we got ownership. Then we got beneficiary designations. If you don't have something transferred by title, if you don't have it transferred by beneficiary, then it goes to probate. Probate is a estate process to dismiss your assets, right? It goes through court, etc. That's where the will comes in. And that's why Christian said that's the third document you have to have. If we've missed anything in titling, we need this will to be able to step up and say, hey, where does all my stuff go?
Absolutely. Absolutely. So that's where the will is going to be super important. Now, is it possible where we pass away, but we don't need to go through the probate process? Is that a possibility?
Yeah, that's actually a really good question. Can you pass away and not have to go through probate? And the answer is yes. If you have titled everything correctly, if you have beneficiaries and everything correctly, then there's nothing left to go to probate. All of the assets transferred without going to probate. So I think that's really, really powerful.
And same thing when I mentioned earlier, when it comes to the will, again, a big if we had the title right, if we had the beneficiaries right, the will is going to be that backstop that we might have forgot something or what have you, that they can get kicked in. But I also will say those are the again, kind of coming back to the three, you got to have documents: advanced healthcare directive, durable power of attorney, and the will. There's also a fourth option there. And depending on your situation, it could be more you got to have versus optional. And that would be a revocable living trust or revocable living trust. And this is where you got to look at your situation to see, is it going to make sense or not? And definitely chat with your advisor and estate planning attorney to go through these options. But a lot of times it could make a lot of sense. And in that case, if we do things right and we utilize a revocable living trust, we also could avoid that probate process, which is kind of nice. That's one of the things that is really nice about trusts and those kinds of documents, is that we can avoid that probate process. It's not a public that's one of the negatives about the probate process. It's a public, process. It can be timely, it can be expensive. The trust can really speed things along, which I like.
I love it. Well, Christian, let's go ahead and talk about where things, man, it's amazing. It's just like every other podcast I always say, we have so many things on our list. I was like, we're not even going to get to half of these things before we have to wrap up our time. But let's chat a little bit more about where things go wrong. Right? Sure. What are some things that you need to avoid? And this one's going to sound a little crazy, so I'm going to ask our listeners, be patient with me, because I'm not trying to put anyone down in this. But this is a mistake I see tons and tons of time. In fact, I taught an estate planning course for financial advisors, and I brought in a pretty well-known estate planning attorney. And when I brought this up, he was like, "No, you're 100% right, Micah." And it's, do not listen to the estate planning attorney on taxes, especially income taxes. Now, it's going to sound crazy to think about, right? What do you mean? They're an attorney. They're an estate planning attorney that's there. And I'm not saying they all get it wrong. Not at all. I'm sure there's some fantastic ones that are out there that can figure this out. But a lot of the times when Christian and I are helping with this, especially with a client and a loved one has passed away, a parent or something, the client is hearing, whether the attorney is saying this or not, could be a different story, but the client is hearing incorrect things. And here's how the story goes. Somebody passes away, there's X amount of inheritance. The question is there any taxes? And the estate planning attorney says there's no estate taxes on this, you're just fine. Well, fantastic. The client's like, there's no taxes on this, I'm good to go. Yeah. And you walk away, you're like, sweet, everything's fine, tax-free, I love this, my two favorite words. However, that's not exactly what he said. What they said was, there's no estate taxes, but in our minds don't register that, right? And there's a difference. There's multiple types of taxes that we have to pay in the United States. One of them is estate tax. Another one is income tax. That's what you and I pay every single year. There's tax returns we got to get filed every single year. So really important to say, hey, we have estate taxes are one thing, income taxes are another. And in fact, Christian, I was working with a client just recently on this. They got an inheritance. And one of the things, whenever a client gets an inheritance, it's like, whoop, all stop. Let's find out where this money came from. And the client says, Micah, no worries. My brother will handle this and it's tax-free. And in fact, her brother sent her a letter. It says, great news. There's no taxes on this. And I'm like, well, that's nice. But I call the brother, who's the executor, nice guy. Go through everything. He outlines out everything that's there, lists off all of the accounts the money came from. And one of them was an IRA. And I said, well, who paid the taxes out of the IRA? Was there any taxes withheld? No. Is the estate paying the taxes? No. Okay, well, someone has to pay taxes on this IRA account, and probably what's going to happen, it's going to get kicked down to the beneficiaries, our clients, that are going to have to pay the taxes. So it's always something to note. Now, when I talk to that representative, again, nice guy. This isn't what he does for a living, right? He's the oldest son, so he's just picking up the mantle and taking care of things. And his comment was, Micah, you don't understand. I talked to the attorney and there's no taxes. That was his comment to me, Christian, right? In my mind, I'm like, I know exactly how this conversation went down, but just because you die doesn't mean you get off the hook paying taxes.
Yeah. Super bad there. But it's just a lingo thing, a language thing. When you hear estate taxes, no estate taxes, we're not thinking about those income taxes there. So that's a really good example there. Well, I would say another place where things can go wrong is kind of two parts to this. One would be if we're not using a real estate planning attorney, and we're just kind of going with a generic attorney that maybe doesn't specialize, or this is their niche is estate planning. And what I mean by that is I'm not saying that attorney is going to do a bad job, but what I'm going to say is if it's not something that they practice on the day-to-day, and we use them for estate planning to put these documents together, that things could possibly get missed. And I have an example. We have a client, again, all of our clients' names are Bob and Sue, kind of makes it nice. So working with Bob and Sue, kind of same thing. They just went with a kind of a generic attorney, and wasn't an estate planning attorney is what I mean. And when they got their wills and we were reviewing them, we noticed, and so Bob and Sue they come what I would consider from a blended family. From previous marriages, they got remarried, they have kids from previous marriages. So what we were going through is we saw in the will that if Sue were to pass away and Bob inherits Sue's accounts, that makes sense. But then when Bob passed away, everything would go to his kids. And Sue has kids of her own. So in that situation, that's not good, because her kids wouldn't receive any of the money. And then vice versa, if Bob passed away.
Christian, what I heard is one spouse is disinheriting all of their kids. They're giving all the money to the other spouse, and they're disinheriting their children by accident, not by intent, by accident.
Yep. That's exactly what happened. And so super important. Honestly, I've seen this happen with estate planning attorneys before as well. It's really important with blended families, if you have that situation, that we really look at when we say this is what we want, that's actually what we want, and that we want to have our kids receive our money. We got to make sure that there's the right estate plan in place to make sure that our kids would actually get that money. Just super something really to be looking at, because we've seen that go wrong quite a few times.
Absolutely. Well, Christian, this podcast is all about action items. We talked about a lot of things with our listeners, right? Some stories that we've had, just things that we work through daily with clients to make sure that they're taken care of. But let's talk about some action items that our listeners can implement this week. Number one, review your documents. Things you think you've written down, go read them and see if they actually say what you remember.
Yeah. Love it. Another action item. Well, if we don't have these documents and there's nothing to review, we got to get those documents, right? Go back. You got to get the advanced healthcare directive, durable power of attorney, the will. Super important. That's got to be on the list.
I love it. The other thing that I'm going to put on here is go fill out your beneficiary forms. Not only fill them out, get them signed off that by your HR, by your representatives, et cetera, that says that they are in place, and get those confirmations back in your own personal record, not just in your EOPF, in your own personal record. If you do those things, you're going to be so much further ahead in making sure you're taking care of your loved ones after something has happened to you.
Yeah. Love it.
Perfect. Christian, thanks so much for jumping on the podcast with me. Always a pleasure. And to all of our listeners, until next time, happy planning.
Happy planning.